Welcome back, ladies and gentlemen. This is Law 254. We seek to demystify the law, give you useful tips and guidance on how you can interact with the law on a day-to-day basis, basically putting the law in your hands. So the COVID-19 has dealt a huge economic blow to many employers, and that is why many employers are reacting by sending their employees on indefinite unpaid leave. Today we want to seek to answer whether it is legal for employers to send their employees on indefinite unpaid leave. So to start with, the fundamental laws that govern employee rights or the relationship as between employees and employers are the Constitution and the Employment Act. In the Constitution, specifically Article 41, which provides for fair labor practices, and Article 50, which provides for fair hearing. Those are like the pillars of how employers need to behave with their employees. And then the Employment Act, the relevant provision for this particular situation of employers sending their employees on indefinite unpaid leave is Section 10.5. And Section 10.5 provides that before any term of the contract as between the employer and employee is altered to the detriment of the employee, then the employer should have consulted prior before making that decision. All right, should have consulted prior before making that decision, and further to that, they should have communicated in writing their decision. So today I want us to talk about the 3 C's that should have been adhered to before the employer sends their employees on indefinite unpaid leave. So usually the law has 2 limbs. There is the substantive law and there is the procedural law. And quite more often employers only adhere to the substantive law, which is concerned mostly with whether it's justified and whether it has adhered to legal provisions. But they disregard the procedural law, which then comes to haunt them later. And I can guarantee you can take this to the nearest M-Pesa shop, that after the COVID situation is over, a lot of us lawyers will be walking and smiling all the way to the bank because of silly mistakes that employers made. Right? So let's delve on the 3 C's. So before an employer decides to send an employee on indefinite unpaid leave, that is an alteration of a term of their contract. It's not limited only to the remuneration. Any term of the employee that is altered, whether it's their workplace, whether it's their working hours, whether it's their remuneration, whether it's their leave days, before any of this is altered to the detriment of the employer has a duty under Section 10.5 and by extension Section 13 of the Employment Act to notify the employee of that alteration. First, to consult, the 3 C's. So the first C is to consult with the employee. After consulting, to seek consent with the employee. And then the last is to communicate in writing. So in law, what has been provided expressly is consultation and communication in writing. The consent bit has been arrived at through determination and through pronouncements by courts over a period of time because of them hearing such cases. So as an employer, among these 3 C's, at least comply with 2. I said consultation, consent, and communication in writing. If you comply with at least 2 of them, then you most likely you will be safe after the COVID situation. All right, and I can give you an example of a case. There's a case of a lady who was working with NSSF, and she had a couple of roles in her job description, and then management decided to strip her of several of her roles. So at the face of it, if you're doing A, B, C, D, and all of a sudden your employer tells you to do A, B, yet you've been maintained, your rank has been maintained, your emoluments have been maintained, your benefits and packages have been maintained. Ordinarily, that's less for more, right? But then she ended up suing the employer successfully because there was an alteration of her contract without consultation. All right. So if someone can actually sue for an alteration of a contract that has nothing to do with what she takes home, what more can someone do when you affect the very sensitive provision in a contract, and that is remuneration? That should even be worse. There was also another case, a KPA employee, Kenya Ports Authority. The person was transferred from the security docket to a HR docket. And the transfer was because the person was accused of being indisciplined, of having questionable integrity, and all the reasons for them to do that were justified. And in fact, court said the employer was justified to have done that, save for how they effected the procedure. So there was no consultation, there was no some sort of consent that was sought, and there was no communication in writing. It just happened arbitrarily, and then they ended up losing that case. So as you can see, employers can argue, but we are in the face of such a pandemic. We do not have money. Money is not coming in, so we do not have salaries to meet our wage bill. That's all right. That's not even contested. The issue is you are justified to do that, but just follow the right procedure. All right, just follow the right procedure, because if you do not follow the right procedure in doing this, then after COVID, you will have yourself to blame, because law is also two-faced. So I hope I've been helpful with that. We'll continue to answer as many questions as possible around this and paid leave, redundancy, etc. Just so employers avoid making costly mistakes, and also for employees to know what their rights are during this pandemic. Thank you, and may God bless you. Subscribe to our channel and look out for more content. Thanks.